Well, let me introduce myself first. I'm Barry Porter. I'm a private attorney in Albuquerque, New Mexico, and I've been practicing criminal defense for over 20 years, licensed in Hawaii and also in New Mexico, and I've handled hundreds of criminal sexual penetration, contact, and SORNA violation cases. Larry asked me to join this, and I got to tell you, I'm very proud to come to an organization like this because something that Jeff mentioned, everybody's kind of treated like monsters out there with these laws. But what we have to do and what we can do is change the story, right? The monsters, the real monsters in this story are these crazy laws, right, that are overzealous, that are not evidence-based. So I really commend all of you folks who are active in this, and especially family members who come to these kind of things to support your loved ones. So for this morning, we have 4 very intelligent legal minds for you. What I wanted to do is make this as interactive as possible. And let me ask a couple of questions to start. How many of you have been to RSOL conferences before? Okay, a good chunk of you. How many of you came to this conference hoping that you would get a question that you have about how the law works or how you can fight the law in your particular state? How many of you came with those kind of questions? Great, right? So the goal here in our 80 minutes together is to each of you get those questions answered, right? There's no billable hours here. You don't have to pay these guys a dime, right? They are forced, and I will force them to answer your questions, okay? But really, we're very privileged to have these 4 folks. Starting at your left is Eric Tenen. Eric has been practicing law for over 10 years. He is with the firm of Swamley and Tenen in Boston, Massachusetts. He specializes in sex offenses, defending sex offenses and collateral consequences. And a real area of expertise for Eric is civil commitment that we're starting to see raise its ugly head in a number of states throughout the country. And he's represented clients before on the Sex Offender Registry Board there in Massachusetts. Then next we have Nancy Forrester. She is a member of the Maryland Bar, the United States District Court of Appeals in the 4th Circuit, and also the United States Supreme Court. Right? She's argued hundreds of criminal cases in the Court of Appeals, and including the Supreme Court. She was the public defender for the state of Maryland in 2004, and she's the president of the Maryland Criminal Defense Lawyers Association. Then to her right, we have Jeff, who we already heard from, also the president of the New Mexico Criminal Defense, of the Ohio Criminal Defense Lawyers Association. I'm on the New Mexico Criminal Defense Lawyers Association. So in relation to a question earlier, is there any kind of clearinghouse? Let's make sure we talk about that and maybe what we can do coming out of this conference. Is Jeff Gamso. He's been practicing over 30 years, has a wealth of experience in appellate practice. He's currently an appellate defender with the Cuyahoga County Public Defender's Office, was a former director of the ACLU, which we take our hats off to all of that good work, and he talked to you about the Bodike case where he was lead counsel. Then we have someone here who's near and dear to my heart, Larry Neely. When we have questions in New Mexico about our sex offender registry, we don't go to a lawyer. We go to Larry Neely, right? Because Larry has been there throughout the process and the different changes in our statute, and I have him as a consultant on a case, and he's just a really valuable resource. He's worked with the Public Defender Office in New Mexico and provided statewide trainings for the Public Defender's Office, helped in other states, including Maryland and Nebraska, setting up their advocacy networks. And he does a lot of writing and research in these areas and assists people throughout the country on those. Larry most recently assisted a Georgia attorney in overturning an unjust conviction in a habeas corpus proceeding. So like it or not, Larry will give us the true scoop. And I'm always mentioning Larry, we got to be more optimistic. So on the point of optimism, the first thing I wanted these folks to do is introduce themselves and tell you a little bit about why they're doing this work. Because it is a special breed of lawyers out there that is doing this work. You know, I have a Facebook page, and I get snotty comments about who I defend on my Facebook page that I have to post. So it's a special group, so I want to ask them to share why they're doing this work. And then we'll go on to our next topic of positive appellate case law that's come out recently. Eric, you want to give us a start?
Sure. Hi. So I'm Eric Tenen. I'm the junior on this panel, apparently. I've been a practicing lawyer for about 10 years, but most all of that time has spent working on cases like this. I sort of fell into this. I didn't go to law school even thinking I wanted to be a litigator or a criminal defense attorney, and then I went to a small law firm, and my now partner and mentor was someone who was doing these kinds of cases, and I just learned how to be a lawyer on these kinds of cases, and he and I are good at what we do, and so we've sort of begun specializing just out of accident. And so Massachusetts, there's a lot of opportunities to work on these kinds of cases because we have registration, we have civil commitment, we just have criminal laws generally. And over time, at least for me, my practice of just working as a lawyer has expanded beyond that into advocacy whenever I can, sometimes in the context of a lawyer, sometimes in the context of my clients, and then sometimes just for the greater good. And I think probably for the same reasons that Jeff mentioned, and probably we all, will say inspired us, and it almost sounds cliche, but it's always true, which is when you finally come into contact with these kinds of laws, you realize just how crazy it is and how there's just a lack of reason and rational thinking going on, and how we have villainized a group of people who don't really deserve it, and the things that are being said aren't quite right, and so you just feel as if someone should say something. In Massachusetts and in Boston, I'm one of the few lawyers, I think, who are willing to talk to the press, for example. I go to trainings with other criminal defense lawyers and criminal defense lawyers who defend murderers and all sorts of people, and they say, "What do you do? I can't believe you do. I could never do that." And so there's not a lot of attorneys who are willing to talk about this and talk openly about it and why it's right or wrong or whatever, just have a debate about it. And I'm happy to do it, and I feel a sense of obligation to do it, and so that's why I'm more than happy to come to a conference like this or give a quote to the newspaper in Boston or whatever it is, because I think the laws are wrong and we're going in the wrong direction, and people need to know that, and we need to educate them. So that's how I arrived here.
Great. Thanks, Eric. Nancy, could you hit the next slide, please? Go ahead.
How I arrived here, is this working? Sort of. Thank you.
There you go.
Sorna.
They're better.
Is I had no idea about these laws at all. I had an attorney friend contact me about her son who, without going into all the details, in college had an incident that he thought was consensual, but turned out she did not agree. And he was charged and was told he had to go on the registry. And so she contacted me as an appellate attorney to, just look into these laws. And I was astonished. I had no idea at all, no clue. And I've been a criminal defense lawyer for 30 years. And the more I read about it and got into it, the angrier I became. And it's not because it's personal to me, because it's a friend. It's just that it's wrong. And I'm one of those obnoxious people that loves to fight, loves to argue. In fact, when I was the public defender from 2004 for the state of Maryland to 2009, when I was unceremoniously fired by the Board of Trustees because I refused to disband a death penalty division, and I refused to disband a juvenile protection division that I had built up in the agency. I was mortified, but then after a while I sort of wore it as a badge of courage, and it's been wonderful for business because a lot of private, people looking for private lawyers love fighters, and that's just the way I am. And so the more I learn about these laws, it's just as I say, it just mortifies me that my legislature passes these kinds of laws, because, really, they're but for the grace of God. Go I. And so I do whatever I can now to fight them, and I'll just continue to do that.
Great. Thanks, Nancy. Jeff?
You probably heard me blather on enough about myself already this morning, but I grew up in New York. Okay, so I was at a death penalty defense seminar that the Ohio Criminal Defense Lawyers Association put on some years ago, and a young lawyer came up to me and said, I'm so disappointed. Every day I wake up and I just want to cry because the courts don't follow the law, and it just makes me so sad. And I said, Mike, makes me angry. Mike said, well, how do you get up every day and keep doing it? I said, the anger gets me going. And you talked about being angry. And the law is an incredibly blunt instrument that with the best of intentions, and once in a while there are the best of intentions out there, with the best of intentions ends up hurting a whole lot of people because, as they say, when the only tool you have is a hammer, everything looks like a nail. And when this was my second career, I was 35 when I went to law school, but I've always been anti-authoritarian. I don't like power in anybody's hands but maybe my own, and I'm not all that crazy about it in my hands, which is good because I've never had any. And if you look around and say who has no power in this society, you're right up there at the top of the list. And if I'm going to do law, and I went to law school as an experiment. I mean, really, I thought, if I hate this, I'll quit. And because I didn't need to do that, I had a perfectly marginally acceptable job teaching English. I was never going to get tenure, but I could string along part-time and temporary jobs in the English department at Texas Tech in scenic Lubbock. But I went to law school as kind of an experiment to see if I hated it, and I didn't hate it. And then while I was in law school, I fell into doing criminal law and pursuing criminal law. And if I'd thought about it, I would have said, no, I'm going to do civil rights law. But I fell into criminal law, which is, of course, first cousin of civil rights law. And if you're going to do criminal defense law, and you're going to do it seriously, and you're going to do it at a high level, and that's what I was trying to do, because that's where, frankly, that's where the excitement is. I was starting out, I'm looking, what am I going to do? When I was in law school, I fell into working with some of the top criminal defense lawyers in town. And, they do the minor burglary cases, but they also do the big sex offender cases and the big drug cases and the big murder cases and the death penalty cases. And so I started doing that stuff while I was in law school. And it kept going. And if you mix that with a level of activism, and you mix that with I was on the board of directors of the ACLU of Ohio for 15 years or something like that before I became legal director. And then I was staff for 5 years as the legal director. And I still do work for them as a volunteer attorney now. And I represent and have represented a whole bunch of people on death row and being tried in capital cases and up through execution, and you do what comes along, and there is so much wrong in this world, and when I can make even a small difference, and I look and I say, they want to pillory you.
Okay, great.
And that's just wrong.
Thank you. Thanks, Jeff. How about you, Larry?
Well, thank you, and we're reversing roles. The last two conferences, I was there, and I'm here this time, and so I'll try to keep mine as short as possible. I am so blessed to be here as the introduction was so gracious, and I just Mr. Porter was the training director for the State Public Defender in New Mexico, and he was actually the first to invite me to provide training, so he must have seen something that others didn't, and so I'm thankful to Mr. Porter, and I'm thankful that Ms. Forrester was, I was privileged to work with a really great attorney in the minor role that I did in Maryland, and I helped with that case, and I've just been passionate about this issue because I was once on the list, and I visited several lawyers. I worked in the law for many years before I ended up on the list, and I visited with several lawyers, and they told me, you can't get off, and I said, oh, yes, I can. And so I brought my own case because, and I realized why I carved out the niche was because I realized when I talked to the lawyers, they didn't know what I knew. So I said, if I'm talking to the lawyers and they don't know, then that explains where we have the problem. So I've been very passionate to try to learn as much as I can from as many states as I can. And one thing I'm trying to improve on, so please forgive me, I don't sound very optimistic because it's a monumental task that we're under. And when an individual comes to with their individual case, unless it has a broader impact, it's like Mr. Gamsel said earlier today, we're fighting the issue. And we want all of you off of the registry. But if your individual case doesn't lead to that outcome, then you're important to you, but you're not important to the cause unless it affects everyone. So that's why I'm here, to try to change for everyone.
Okay, I think thank you all. That makes up a very good point, is a lot of you are in jurisdictions where you don't have lawyers that know this stuff. So it's so great that you're here and willing to learn. And don't be bashful about reading case opinions, about getting the statutes. Maybe just get a lawyer, hey, give me the stuff. I will read it. I will dissect it. So kind of along those lines, let's hit the next slide, please. And we're going to talk about the most favorite opinions that you folks have come across in the last year or so. If we can start with Eric, rather. Eric at the end there. And the idea behind this is you want to learn what other jurisdictions are doing, because sex offender registration laws are all state by state. So if an attack worked in Kentucky, well, maybe it will work in North Carolina.
So I'm from Boston, from Massachusetts. That's a jurisdiction where I practice, and I'm going to be talking tomorrow a little bit about specifically Massachusetts and how we go about classifying and registering individuals, and it's very different than what I think most everyone is used to. And so I'll explain a little more at the time, but along those lines, one of the reasons it's different is because we have a very, I think, smart and intelligent court in Massachusetts, the Supreme Judicial Court, and one thing they are very receptive to, or have become receptive to, I should say, and this is across the board, but including issues about sex offenders, is about research and what we know empirically about these issues as opposed to what we feel about them, what we think about them. And so there have been a series of cases that I have been a part of on some level or another where the court has acknowledged specific research about specific groups of offenders and why they're different and why our registration scheme doesn't properly capture that. And why it needs to, and essentially has resulted in overturning classifications of persons because they're a part of these groups that the research tells us is different. And so we've had cases, for example, about a female who had to register, and how the way we classify persons doesn't take into account the uniqueness of females, and so they overturned that and sent it back down. Juveniles, everyone probably knows, is different, and the research tells us they're different, and so our scheme didn't take into account that and reverse the classification and send it back down. Older offenders are different, the research says that, and they overturn that and send it back down. So there have been a series of cases where our Supreme Judicial Court has acknowledged that everyone is not the same, and you need to do individual, or you need to look at them individually, or at least what the research tells us about that. And we've had a lot of success in Massachusetts about that, and that will be one of the things that I will probably bring up every time we go around here and in my talk tomorrow, which is I think one of the best things we can do is actually use research and evidence, things from people with doctorates and who know how to crunch numbers, and use that to show it's not what you think. It's not what you think. You've been wrong about it. And like I say, our court has been receptive and has resulted in just these series of opinions, not just about, GPS, about online offenders. They've been receptive to all of it. Again, I'll talk a little more about it tomorrow, but it's not necessarily the most, from this year, but it's probably in the last, 4 or 5 years that these series of opinions have come out, always on our side, always, because the court will accept what we're saying about the reality of things.
And can I follow up real quick, Eric, on, where did you get that research? Where are you finding it? What are the sources?
So part of it, for me, comes from doing a lot of work on the civil commitment side of it, and that might be unique to a lot of people, and not every jurisdiction has it, but the way we do it in Massachusetts involves essentially a battle of experts. And so I had to learn, square one, how is it that people talk about sex offenders? When a doctor says someone's dangerous, where does that come from? And apparently there's a lot of research. And I have read a lot of research, and you just build on it and build on it, and you just start to develop a pool of knowledge, and that's shared among attorneys in Massachusetts. And so I think the bar in Massachusetts who does that is very well schooled about this research. And in conjunction with some of the doctors we work with, that's where we get it from, and we put it together, and it always gets put into any of our court cases.
Okay. Folks, if you have questions along the line, I want you to be able to ask them real quickly. These are not, you can't be case specific, but if there are issues that you want to address real quick, I think it will move along better. Yes, ma'am. Yes.
Thank you. I just had a question. I have a master's in gerontology and I've worked with people with dementia most of my life. So this is an area that I've been really interested in. And when you say older offenders, do you mean just older offenders, or do you mean people that have memory loss and confusion issues?
Good question. That was a very broad term. No, what I mean by that is there's a lot of research that says the older people are when they are released from incarceration or whatever it is, the less likely they are to reoffend. So when I say older, I mean just strictly age. Persons over 50, over 60, and their rates of recidivism as compared to others.
Okay, next question.
When you talk about research and having access to a pool, are you working with ATSA?
I work a lot with MATSA, which is the Massachusetts chapter of ATSA, and so I know a lot of the doctors there. So, and a lot of the doctors I use in my practice are members of that too. So that is one way I get some of that research.
Do you attend the ATSA conferences because it's international to get the first?
Right. I personally don't do that, but I just I feel like I'm connected well to other psychologists that I can sort of stay current with it.
Okay. Last question, then we're going to move on to Nancy. Go ahead.
Is my attorney able to contact you to get access to
Sure.
research?
Sure.
And then my second question, have you done research or come across research with someone that has a learning disability?
That might be a little too specific. I don't, off the top of my head, I don't think so. Let me think about that, and if I have something, I'll talk to you after.
That's a great question, and I, as a follow-up, want Eric to post all of his research that he's found on the RSOL website, if possible.
That might be a little trickier with copyright and stuff, but we can figure it out.
Let's figure something
Yeah.
out. Great. Nancy, tell us about your most favorite appellate opinion.
I would say it's mine.
Okay.
No, I was in it later this afternoon. I'm going to talk about the Maryland cases, but because of one of the cases in Maryland that I happened to get the highest court to say that the ex post facto law had been violated by retroactively applying these more harsh every single year amendments to the legislation, and therefore I think so far we've had 800 to 1,200 people removed from the registry because of that. But more importantly to me now is, and these are recent opinions out of the Maryland highest court, that they are now applying that case, Doe, and saying, oh, well, you can't increase a person's time on the registry retroactively, because I'm sure, as you all know, at least in Maryland, the time on the registry originally was 10 years. That went up to 15, and then 15 to 25, and then some went up to life. And so there have been several cases in Maryland that have come out that said, no, you can't do this if your original term at the time you committed the offense was 10 years. We don't care what the law says now, because they've actually recategorized many of these 10-year offenders in Maryland to Tier 3, lifetime offenders. So because of these new cases coming out in Maryland, those folks have either already done their 10 years and have had to be removed, or they're being told, no, only 10 years, not life. So that's very, I think, exciting, because what the courts have been doing in Maryland, and it's the highest court as well as the intermediary appellate court as well, are building on the Doe decision and applying it not just to specific, like if your offense was committed before the registry even existed, which is what the Doe decision said. They're now applying it to other aspects of the law, which is very encouraging, to, at least to me and to the registrants in the state of Maryland. And we hope that that will continue with not just your time on the registry, but also to the number of restrictions where that may have been increased as a result of new laws. So it's an exciting time, at least for me as an attorney handling these kinds of cases in Maryland, because the courts in Maryland are very receptive, the appellate courts, that is, are quite receptive now to applying Doe to a much broader class and category of folks.
Okay, I want to follow up with a quick question on that, and then I'll hit yours. So, Mary, that's a great opinion in Maryland, right? Why can't I get my New Mexico courts to follow it?
Who's their lawyer?
Well,
Just kidding. Just kidding.
there's a lot of us.
Just kidding. No, Maryland. Look, it took a long time. This is not like overnight. It was a long time coming, because Maryland courts, just as the Supreme, they were wedded to the Supreme Court Smith v. Doe decision, saying sex offender registration is not punishment. Right? And we could not get them to budge off of that. It's not punishment. So therefore, when you say it's not punishment, ex post facto doesn't apply unless it's punishment. And so the tack that I took in the Doe case was, I'm not talking about the federal Constitution. I use the Maryland Constitution, which is different. And so that is one thing I would urge all attorneys in states, is to look at your own state's constitution, because it's much more difficult to get the court to say it's punishment relying on the federal constitution.
Perfect, exactly, yeah. You have a question?
Can you speak to, in general, what grounds were there for reducing the tenure of some of these registers?
Because when the thing is that you look at the time the offense was committed, what was the law at that time? And in most of these cases, the law in Maryland at the time the offenses were committed, it was a 10-year registration period. And at the time, prior to 2010 in Maryland, there was only a 10-year term, or there was life. Except for certain circumstances, very little in between that. And so you look at the time, the laws that existed at the time the crime was committed, which almost, in most of my cases, it was 10 years. And so what the state was trying to do is saying, well, these new laws say now it's life. So you have to be on there for life. But the new cases that have been building on Doe say, no, you can't make it retroactive. That's a violation of the ex post facto.
But you're able to get some tenure actually reduced from the original sentence?
I'm not sure I understand your question.
I understood you to say that you actually had some tenures for registrants reduced in time.
Your time on the registry?
Yes, ma'am.
Yes. Oh, yeah. I've had several people who they increased from 10 years to life, taken back to 10.
Okay, back to 10, not
Correct.
less than 10.
No. It's 10 was always the lowest it was ever going to be.
And it's important to note, and I don't know how much law you folks all know, right, is that Mary's attack was under the Maryland state constitution, right? If you would have walked across the street into federal court, they would have said, you're SOL, right? And you're SOL because this isn't even punishment, right? And so it varies in state to state as to whether or not being placed on a sex offender registration is punishment. If it's punishment, then ex post facto applies. If it's not punishment, we're left where we are in I think, a majority of the states.
Yes.
Yeah. Okay, thank you very much, Nancy. Yeah, go ahead.
Doe makes that pretty hard to find. Do you have a citation or a year? Or how
I sure
that
do.
works out? Thank you.
Hang on, I wrote it down, although I should know it off the top of my head.
Yeah, so this is a good case to pull from your archives in your local jurisdiction, pound on the door of the public defender's office and say, hey, I want some movement.
Actually, the public defender's office in Maryland, anyway, can't handle these kinds because they are civil.
Civil, yes. So then maybe you're going to a legislator. It's like, we need counsel for people to have representation.
The Doe case is 430 Maryland 535 2013.
Great. Okay, let's move on with I'll get your question in a moment. Go ahead.
Oh, I'm sorry. It's 430 Maryland 535 from 2013.
Great. Now, Jeff, let's hear the good news from you, or do we already hear what you have to say
You pretty
about
much already heard it. My favorite case is Bodike. Or maybe it's Williams that came afterwards that I mentioned that I had, well, I guess I was probably amicus counsel in it, where we finally got the Ohio Supreme Court to say that sex offender registration under the Adam Walsh Act, unlike all previous versions of the law, was punitive, but that's the throwaway line because we don't have an ex post facto clause, and they didn't decide the case under the ex post facto clause, but under Ohio's retroactivity statute, which is unless the legislature specifically makes it retroactive, it's not, and they didn't. And that's won us a lot of really good cases in other oddball sorts of ways. So it's worked for residency restrictions. And that's where we've really been effective in getting people essentially grandfathered into where they live when the states tried to evict them from places, or in Toledo tried to actually convict them of zoning violations for living in one case, in a place where there used to be a school, and gee, there might be one again someday.
Great. Thank you, Jeff. Oh, yes.
Just curious, if you were to even remotely say, okay, registration in and of itself is not punitive, because I've heard it argued that, well, it's just like going down and registering your car or, anything else. It's just purely an administrative function, and that's what they told us in my son's sentencing. The registry is just administrative. So even if I were to buy into that, so if registry in and of itself is not punitive, what about all of the other legislation that layers on top of it that says, if you are registered, then this, and then this, and then this, which are punishment. They are punitive. Has that been argued?
I'd like that. Yeah. There, you ready for that one, Larry?
I'd love that one.
Okay.
Hey, Larry.
Well, see, what happens is that the case I'm going to talk about, in addition to my favorite Maryland case, is that registration in and of itself is not punitive. We register so many things in this country, from school children to young men for the draft, from guns and boats and cars. So merely the act of registration of something is not punitive. So you have to look at what's being required to do the analytical. You have to analyze it under the framework of the U.S. Supreme Court, which is Kennedy Mendoza Martinez, which is a 1963 case. And they apply a 7-step analysis. And Ms. Forrester can probably come closer to naming all 7 than I can. But the case, when it goes up, it has to be developed, alleging that it is punitive and building the evidentiary record by a declaratory action, which usually these don't go up in the proper vehicle. They go up because some public defenders tried to file something because the person's saying, hey, I was supposed to register for 10 years, now I'm getting violated. So it's the reason why those questions haven't been answered is because they haven't been asked. No one has filed a declaratory judgment asking those questions and building the evidentiary record and establishing a record so that we can get an answer from that state Supreme Court.
So how do we do that and push it? Because that would then apply to all registration, and that would perhaps be the pathway that we take as a collective to file, to direct it to the U.S. Supreme Court, because it affects everybody.
You don't want to go to the U.S. Supreme Court.
Yeah.
You can tell I'm not an attorney.
If you were to go to this U.S. Supreme Court, you'd have a 6-3 decision saying that despite all these amendments, it's still civil and regulatory.
So if we put together something along those lines, that, okay, registration is not punishment, but it's all of these other things, and we build the framework for this case in such a way that it's so clean that it could be adopted and used and pursued in each state. I'm confident. I know we've got attorneys in Florida that are just frothing at the bit to have the right type of thing to take up. Funding is the issue, but I think we could, as a collective, get something like this funded, but we need to have the right framework.
Well, and like Jeff mentioned, like the attack that they did in Ohio, you've got the Marshall Plan, so to speak. You want to cherry pick your case, right? You figure out which court is the best to maybe have success in which state, because you're looking at individual states. And I love this idea, and I'm kind of curious about you guys. You know, you're being proactive. You're going on the offensive when you're moving for a declaratory judgment. You get to control which witnesses are called, what testimony is had, which litigant is brought before the court, right? So you really get to do that cherry picking versus most of the time, right, we've had somebody who's violated, and now we're trying to say, well, they should never have had to register anyway, and you're really on the defense, right? Have you guys had any success with declaratory judgment work? Yeah. And actually, Eric, could you explain the difference, just in case people don't know, of what is going in motion for declaratory judgment?
We do this a lot in Massachusetts for a variety of reasons that are probably too complicated to explain right now. But we do litigation in anticipation as opposed to reactive, which I think is a little bit of how Jeff was talking about it. So you know a law is coming, or someone might be subjected to it, and so you file an action in court saying, listen, before this goes into effect, I would like you to declare that this law is unconstitutional or doesn't apply to this person for whatever reason. Maybe it's a statutory argument. And then I would like you to issue an injunction, essentially telling whoever it is, the Attorney General or the board, or whoever does it, not to enforce it against that person. And if you're really good and fast and lucky and have a good case, you can get a preliminary injunction which says, before you even decide this issue, it's so troubling that this person might be subjected to it that I would like you to say, don't enforce it yet until the case can be heard. So we do that a lot. And in a lot of these cases, again, for a variety of reasons that are complicated, we have the ability to do that and go in before the fact. And that's when you can pick your plaintiff and pick your evidence and pick your complaint and know exactly how you're going to do it, as opposed to reacting and saying, yikes, he's just been charged with failure to register. Let me think of all the things I might be able to do to undo it. So it's very hard, I should say. And I have one quick theory. Did you say you're from Florida? Mm-hmm. So I just asked Nancy if Maryland, if the judges are elected or not. She said they're not elected. They're not elected in Massachusetts. In Ohio, are they elected or not?
Oh, yeah, elected.
They are elected.
They're elected in Florida.
And they're elected in Florida. And New Mexico?
Elected.
Okay, so your question is, why can't we get this done in New Mexico or Florida? Why is it so hard in Ohio? It's a lot easier when you have judges who are not elected. That's just a fact. And so it's a lot easier in Massachusetts when they don't feel that push, and probably in Maryland, and a lot harder in Ohio. And I know all about the fights of elected judges in Florida, and you have to factor that in too. And that's what you're up against also.
Great. Yes.
Building on what this one said from Florida, just dawned on me from John Hall. Has there ever been a class action lawsuit filed on behalf of everybody who suffered punitively from?
I'm not aware of one, but
Well, That might, if you want to wait till we get to facial versus as
Yeah.
applied, I think
Yeah.
that I have an answer at that point.
Okay. We're going to defer that. All right, we'll come back to it. Okay. Yeah. We skipped Larry on his favorite case, so let's hear what Larry has to say about his favorite case.
Got to get my favorite case in here, although already said it. My favorite case, of course, is the Doe decision, especially Doe number 2. But that's not the one I'm going to talk about. Doe number 2 was so favored because the state created arguments that had never been imagined except by me, because they will argue anything that they can dream up, and all your state attorneys general will do the same thing. So nothing unique about Maryland. But my favorite case is a case that just came out in February from the New Hampshire Supreme Court. And looking at the decision, you think, wow, I'm reading through this. This is the best reading material I've ever had. So they go through this. It was a declaratory action, and they go through all of these amendments, starting from when the registration began in New Hampshire in '92. And then, does anybody have any idea how many times it's been amended from '92? How many different?
11,977.
It's been amended 10 times. So, and of course, you can imagine each time it was amended, there was enhancements. They didn't make it easier. They added different requirements, different disclosure of information. So they made it far worse. So this elderly man that couldn't get public housing because he's now under the most recent amendment, a Tier 3, and he's not allowed to live in public housing, he brought a declaratory action. So I read through the 29-page opinion, and I get to page 25, and I said, wow, this is going to be a slam dunk. And because they've got everything just right. Well, but you get to the remedy, because they said, gee, we've been relying on Costello all these years, which every state has a Costello case, and New Mexico has Dructinas, where the courts have looked at registration and said, we're marching in lockstep with Smith versus Doe. Maryland had a case. They all do. So they said, well, we're going to depart from Costello now. Well, we've seen the light. This is unconstitutional. And I said, wow, we've won this damn thing, although I wasn't involved in it. But they said, well, guess what the remedy is? Because the law is unconstitutional, they have to do something with remedy. And they said, we just can't let all these people off of the registry, because that would be the result. So they said, we're going to do a remedy that's very unique. We're going to say that it's only unconstitutional, not because of ex post facto, not because of punishment, not because of all this stuff, because these people were changed from 10 years to lifetime, or either 25 years, because that's the tiers, and they don't have a way to get off early. The Tier 1s can get off, there's a 5-year early reduction for good behavior. So they said, so since there's no due process provided, the sex offender can file a petition in a non-existent format, in something, they said, well, we're sure the legislature will come up with something to address us. So the remedy is that the sex offender bears the burden of proving that they're no longer dangerous. And if they're no longer dangerous, they can have this hearing in a format that doesn't exist, and they can get off the registry. So now it's good for the lawyers in New Hampshire, because the people who have money, of course, they're going to go to a lawyer and say, I want you to file one of these petitions. And the lawyers are going to say, Neely, what do you want? What the hell do I write up? And I said, well, here's what we write up. But right now, this is just chaos. It's going to be total chaos. And it's a brilliant decision, except the remedy is awful. But that's what they did. And so I want to get my claws into trying to help remedy what I think, and we've been thinking about what we can go. There's nothing really to do. It's the state highest court, so we don't know what to do.
Go ahead.
What's the name of that case?
It's John Doe versus the state of New Hampshire.
You have the site? Can you give them the site?
So 2013-496, New Hampshire Supreme Court.
How many folks are from states where there is a statutory way for somebody to petition to get off of the registry? Wow, okay.
There is a Florida.
But what? But it doesn't happen. There's this mechanism, but it's not happening. Yes.
Yeah, and most registrants in Vermont don't know.
Okay.
They just don't know.
How many people are from states where there is no mechanism to get off the registry? Okay. Okay. So this is okay. Great. Well, let's get into that. If we could hit the next slide. What I want to go into now is challenging the constitutionality of these laws and strategies that you folks can develop and strategies, ideas from all of these folks. That's basically our main topic here. The first question I wanted to ask you guys is, have you ever been around when laws are made? Up at the legislature, we call the crazy house is the round house. Our legislative building in New Mexico happens to be round, and a lot of craziness goes on there. I wanted to ask any member of the panel, before a law is passed, like a registration law, does the legislature clear it for constitutionality? Do they, in your state, what's the practice, as far as you know?
No. There are legislative aides. There are the people who draft the law. There is some, in Ohio, there's a legislative service commission that reviews the laws and explains how they work and what they will cost and makes projections. And the people who vote for them either think they're constitutional or don't care. When Arlen Specter voted in favor of a law in 1996, actually, in the U.S. Congress, he said, "I'm voting for this even though I think it's unconstitutional, and the courts will later change their mind, will later throw it out." They didn't. But, no, nobody decides these things. They do what they want to.
Nancy, what's your experience in Maryland?
In Maryland, the legislature happens to be made up mostly of lawyers in Maryland, or a good majority are lawyers, attorneys. And so they are cognizant of whether or not the law is constitutional, but the way they handle it is they will ask the Attorney General's office for an advisory opinion. Now, they can't be held to the opinion, but it certainly is, it helps the legislature in deciding whether or not it is or is not constitutional. If the Attorney General's office writes an opinion saying there's nothing constitutionally wrong with this, then they're much more comfortable in passing it. And that's pretty much what they do in Maryland.
Okay.
In Massachusetts, probably the same in the sense that they don't vet it, except for there is a very underutilized provision of our Constitution that allows the legislature to ask our Supreme Judicial Court for an opinion which is binding prior to enacting a law. They use it sparingly. They just used it because there was a fight between the House and the Senate about a budget item. They did use it way back in the late 90s when they passed the first version of our registry law, which our court said, these are some of the problems with the statute. They then changed the statute to fit that and then passed that. So, but it's very sparingly used. This is why you want to be able to have well-timed litigation that you can try and do before a law goes into effect, because it gets passed. There's some time between that and going into effect, and if you know it's coming, you can get into court and try and do that declaratory action that we talked about before.
I should add that, we do go into court. We do go and testify in front of the legislature, and I've been a registered lobbyist in Ohio at various times. I'm not now, and registered or otherwise, people go in the legislature and testify and say, no, this provision is unconstitutional. Do something about it. And once in a while, they do, and other times they say, we don't care.
Following up on that, Jeff, I know Larry Neely does a lot of that in New Mexico. Larry, can you talk about what a citizen can do as far as, when a bill is proposed in the legislative house to oppose it?
So, well, I would say in our state we have one of the better review processes, although it's far from perfect. There is a legislative counsel service which advises the lawmakers. There are attorneys to the lawmakers, and all this stuff goes through drafting through the counsel service. But if the lawmaker says, despite your concerns, I'm going to go forward with the legislation, then sometimes the counsel service will come in as a nonpartisan and say, well, we do have constitutional concerns. But it goes forward. If the public sentiment is for that piece of legislation, chances are the people you elected, if you're telling them in great numbers you want this, the way the lawmaking process is set up, if the room is filled when they're taking public testimony and people are saying they're for it, that's representative of the people. So the people are in the roundhouse saying, we want this, and if they say, how many for it in this room, and everybody except one, that's what they feel the people want, and they'll go ahead and say, we'll pass it, and it's presumed constitutional, and absolutely, once it's passed and signed by the governor, except for the clearest of proof, it stands. So what we can do as citizens is be in the process, communicating with our lawmakers, telling them, you do not vote for this. I mean, like when the food stamp thing was banned, what the doofus down in Louisiana, his phone should have been ringing off the hook saying, you're going to take food and nutrition assistance away from people because of a mistake they've made? How dare you? But he wasn't getting those phone calls. He was getting phone calls saying, amen, brother, amen. These people don't deserve anything. That's the kind of phone calls that he was getting. So that's how we influence. We show up at our Capitol. We sit in those rooms when they're hearing those bills. We raise our hands in opposition, and we say, no, that is not what we want as citizens.
Be active, right? Change the story, right? The monster in the room is these bad laws. You had a question back there?
Is it possible for one of the panelists to follow up with the federal laws?
Sure.
I mean, I'm in a case that's under the federal jurisdiction.
Okay.
I don't know what to do or where to go.
I join you in that. I have a federal SORNA case pending right now, right? And it's really horrible because you have these sentencing guidelines, and so sentences are kind of just predetermined, and they're much harsher than in state court. In my particular case, if my guy was convicted just across the street in state court, he'd be probation and out, right? But now he's looking at federal time.
What federal time are you looking at?
It really, the federal sentencing guidelines are like a grid, right? And you on the top part of the grid is the criminal history, and then the criminal offense. So where that grid meets for each individual is their sentencing range. My particular guy is looking at 24 to 33 months. Right? Months, yeah.
In our case, we're looking at 30 to 40 years.
Yeah, so that... For just a registration violation or a sex offense?
The actual sex offense he's talking about.
Yeah, I was talking about just a registration violence. Sex offense, then on your offense categories, they go crazy on the federal sentencing. And sentencing guidelines under this Booker decision are no longer binding on a court, but most federal courts seem to follow them a good deal of the time. Yes?
This is a question I was asked to ask. Is there any research being done challenging the constitutionality of SORNA laws on the basis of habeas corpus?
On the basis of habeas?
What do you mean?
I'm not sure I understand the question.
That's it.
Well, habeas means you're illegally detained.
I think I know what he's asking.
Okay. All right.
What he's trying to get at is, in order for a court to have jurisdiction in a habeas corpus proceeding, a person has to be in a form of in custody. And in custody is defined as being physical custody in some states. And Arkansas is one of those where you have to be in physical custody. And he's from Arkansas. And so therefore, it's not it's very bleak in Arkansas. But to my knowledge, and we've got lawyers here who may have greater knowledge, but there has been no determination that the in custody requirement for a federal habeas corpus action can be met by having to register. And that's where you're going with that question.
Yeah. I'm not aware of anything either. Yes?
I just wanted to quickly share that the Colorado criminal defense bar has just gotten a JAG grant, which the public defenders, of course, belong to the criminal defense bar as well. So what will happen is that in the fall, the public defenders will start explaining to people who can get off the registry how to do that, because what they found is that one of the big issues is that people who can don't know how. And so there will be instruction from the PDs, and then the lawyers, the criminal defense lawyers, will actually take on those cases on a formal basis because of the grant.
That's great.
Help people get off the registry. So juveniles are people that have lower.
And you say JAG.
Judge Advocate General.
Oh, yeah, is it because Colorado has such a large military presence? Or that's
I have
an
no
interesting.
idea why they got
Okay. Okay, I had a question over here. Oh.
Over the last 33 years, we've been dealing used to have to register annually, and that lasted for about 7 years, and then got a new generation in, and now it's every 90 days. And actually spoke to my representative about the law, and he said that wasn't their intent. So, I mean, my point is that might be another way to attack it is what the legislative intent is and the way it's being implemented as it's gone on. You know, we let police decide, you know, who they're going to lock up. It's going to be a larger percentage.
Sure, and in some states, in New Mexico, actually, you can't really use legislative intent as part of your argument. Some states allow it.
It's hard. It depends.
Yeah, it's
Okay, good.
the second thing.
Okay, good, thank you. Take one more question and we'll move on a little bit. Back there, you haven't asked.
A little off topic. I do a lot of work with juveniles, so, because I was a juvenile, I spent 10 years in juvenile system. So, one of the things I'm trying to work on now is we can tear it apart is has anybody went after the constitutionality of the Fifth Amendment violation of making juveniles make disclosures? Because what happens is, if the first part of the treatment, they make them make all these disclosures in these inpatient treatment programs, and that's kind of the main way that they get to say, look, these kids are dangerous, which we all know they're not. That's statistically speaking, juveniles don't tend to grow up to be these predators that make them out to be. But they make a lot of money off that. So anyway, and it gets used later. All these disclosures these kids make, nobody tells them this can get used later against them in court. And it does. It happens all the time.
There are a smattering of cases here and there around, well, there's at least one in Ohio, and there's a few others around the country that say very specifically that if you're forced to do, and more broadly, there's a general rule that if you are forced to speak, that can't be used against you later. That, like all the laws, they're so riddled with exceptions that you can't necessarily count on.
Well, and the problem is, what does it mean to be forced? And there actually is a U.S. Supreme Court case that talks about this, McKeown v. Lyle, or I forget the name, that talks about offering incentives or disincentives. So saying if you don't participate in treatment, your custody will be increased or you'll lose your job or whatever it is. And so the real fight is, what does it mean to be forced? So the court said that's not force. So if you don't want to talk, you can lose those things.
Yeah, the typical threat is that they will go to the juvenile lockup system versus the inpatient treatment. So
it depends. Right? You have to have that fight. Is that force or not? And you have to get a court.
That's really a regular statement suppression kind of issue. And in a lot of states, juveniles have greater protection over being interrogated. So it's going to be state by state, and that can be challenged at the get-go. Right, so before somebody gets convicted, there could be a motion to suppress the statement.
As Eric says, within state by state, it's going to be case by case.
Right. Yeah. Can we advance 2 slides, please? Okay, so you want to, what happens is they keep on passing more and more burdensome laws, right? And each time they add on something, and we're trying to say, well, this is now punishment. You now added a geographical restriction. It's now punishment. And we want to attack that in court. We want to do the declaratory judgment. I want to ask our expert panel here, who has the burden of proof? If I'm moving for a declaratory judgment, and what's the standard of proof? And what's the difference between burden of proof and standard of proof? Yeah, Eric? Great.
To be first in all these. So burden of proof means who has to prove their case. Which side. So if you're the person bringing the lawsuit for this declaratory or injunctive relief, you have to prove your case by whatever standard. Standard means is how much do you have to prove? So we all know criminally the state has to prove beyond a reasonable doubt that someone's guilty. That's a standard. And so with civil cases, it's a little different. And then I think the other question sort of wrapped is what do you have to prove? And that's a little more complicated. And so it depends on what you're challenging. So if you're saying this is unconstitutional, okay, well, which provision of the Constitution? If you're saying it's a violation of due process, well, which provision of due process are you saying? And then it depends on It depends on, are you saying this affects your liberty interest, which courts say, well, that's a fundamental right, and any statute that affects a fundamental right has to be narrowly tailored, so you have to prove that the statute is not narrowly tailored. If it's not fundamental, if it's maybe equal protection, there are broader, you have to prove, well, just that it's not, the law has to be rational, which is a much harder thing to show a law is not rational. So it depends on what the basis of your challenge is. They can be very hard, it can be a little easier.
And then which constitution are you talking about, right? How many folks have brought anything in federal court challenging a SORNA scheme? Yeah, right? Not a very popular place to go, right? And that brings up my next question is jurisdiction, right? What jurisdiction do you pick, and what is jurisdiction? Nancy, can you kind of explain that? Next slide, please.
Right. Well, you can either go into federal court or state court if you're doing a declaratory judgment type issue. But if you're in federal court, you're limited to the federal laws. And again, it gets to what we were saying before, is that or at least in my experience, the chances are better when you're challenging at the state level instead of the federal level. And for me, it was better to challenge under the state constitution than the federal constitution because of the interpretations of this Supreme Court of federal law, and past Supreme Courts actually, of the federal ex post facto laws are very, very hard to overcome because nothing seems to be punishment in their opinion. So I happen to be fortunate to convince the Court of Appeals in Maryland, which is the highest court, that the standard we use under the Maryland Constitution ex post facto challenge is completely different based on case law, old case law, and they agreed and said that the test or the standard for determining whether a law violates Maryland's constitutional ex post facto prohibition is whether the law, and I just use the exact words, is whether the law changes the consequences of the crime to the defendant's disadvantage. That's a very easy standard to meet when you're talking about sex offender registry laws. And I don't know of any other court across the country, and I'm not saying that Maryland's the only one, I'm saying I literally don't know if any other courts across the country have used such a standard. But Maryland chose to adopt an easy standard to say that this is definitely punishment, because you can easily say that the consequences of your actions this is now a disadvantage to you. So we were quite fortunate to have that standard the court imposed.
Great. Could you hit 2 more slides, please? So one more. So facial versus applied, as applied. Eric, you were going to address this?
Oh, sure. So when Jeff was talking before about, you're special to you, but you're not special to everyone. That's one way of thinking about this. So sometimes you can challenge a law and say, look, this law generally might be fine for other people, but it's really bad for me for a very specific reason. That's what they call an as-applied challenge. So the law as applied to me or as applied to my client is unconstitutional because whatever, he's a juvenile or he's this or he's disabled, whatever it is. And you don't have to say it's unconstitutional for everybody. Everyone else it can apply to, but not for me. And that's when you can bring one case on behalf of one person who has a good fact pattern and make some opinion that hopefully can be used for others, but really just applies to that person. Facial attack means this law is unconstitutional pretty much for everybody. And so you shouldn't let it go into effect because maybe some broad theory, it's ex post facto or something like that. It doesn't matter who you are, or what you did, or whether you're 20 or 50 or this or that. It can't because your crime was old. And that's a facial challenge, which is harder because it's broader. So you were asking about class actions. I don't know if that's quite the right term, but a facial challenge is essentially one that's going to affect people as big as a class. Everyone whose crime occurred prior to this, that's a class, they will all be affected. And as applied is just this one person. Maybe you can use it later for others, but it's just this one person, it's not everybody. And so those are different ways of thinking about it, and sometimes you can do both. And we've had lawsuits that is broad and as applied to this class of plaintiffs.
Anybody else want to address that? Larry?
I just would like to ask a scenario, maybe it'll help illustrate it a little bit better. A facial challenge is the most difficult to mount because you're alleging that there's no set of circumstances where this law can operate. But, for example, as applied, what if for speeding, your legislature in this great state of Texas said that the fine is $100. And then if they've passed a law and said, well, we've changed our mind, and the fine is up to 3 years in prison for speeding. Well, if you were 1 day before that law passed, you could do a facial, an as-applied challenge and say, well, it may be that 3 years in prison may be okay. I'm not arguing that point, but I'm arguing that they've looked at my date wrong on my ticket, and I predate this, so therefore you can't apply it to me. But if it's facially invalid, you'd have to argue, well, you can't apply a 3-year possible incarceration to anyone because of a whole litany of arguments you could make about it being cruel and unusual. Probably none of it would work. But you could do. That's when you say you just can't do this. Period. And there's some things that are just clearly you can't do, like in the First Amendment area. But it's got to be clear that this is just so obnoxious on its face. You cannot have this law. And lawmakers have broad discretion. You elect these people, and to have these people in robes taking your power away from you to have the laws made is a very drastic remedy. And most people don't like that, especially if it's a law that they support. So courts tend to be very careful in nullifying what you've done through your elected officials.
There was just last week, I don't know the name, but the U.S. Supreme Court decided a case, a Fourth Amendment case. Did you see that? Mm-hmm. See that about right? It was a facial challenge to a law that made hotels turn over information to law enforcement without a warrant. I don't remember the name, but it was close. It was 5-4, but they said you could bring a facial challenge, and I thought it had very good language generally about when you can bring or how you can bring a facial challenge that I thought it's helpful. I think it actually makes it this much easier. Things happen.
So the facial challenge is a little bit akin to your question about class actions, right? So because that would then apply to everybody. Right? Otherwise, you're just going in and knocking it down as applied to that one particular plaintiff. Yeah, go ahead.
Wouldn't a class action be more like an as applied, only to us, rather than just me? Just a group of people saying...
Okay, so the question is, wouldn't a class action be applied as to a group of people, us? It could be.
Yeah, class actions are tricky because that every person in the class has to have the same trait, and you don't always have that, and so you have to attack this common trait, and so it's not, I think in terms of these laws, it's not a great way because everything is so, in theory, individualized why this person shouldn't or this person shouldn't.
Has anybody on the panel heard of a class action suit in a SORNA setting?
Well, yeah.
I just filed one.
Okay, good. Well, let's hear about it.
I take it back. It's a great way.
I just filed, a month ago, I guess, again, based on the Doe decision, saying that we have 3 classes of folks that are covered. One is those whose time on the registry was increased. The other is those whose restrictions under the law were increased. The other is, what is it, Larry? I forgot. There's, I can't remember, but it's very nuanced, if you will. But anyhow, I just filed that a month ago to try and apply the Doe decision to as many folks as I possibly can, and to argue that the fact that the state doesn't do it is unconstitutional.
Is it a class? Are you certifying a class?
Mm-hmm.
Mm-hmm. So certifying a class, you have to have representatives of each class?
That took a long time. Yes, I had to, with the help of FAIR, get my litigants, if you will, my plaintiffs, to represent each one in that class. And of course, talking about picking the right plaintiff is critical because while I had some folks who would, perfectly fell into one of the groups I was trying to represent, I had to be very discerning because it's going to hit the newspapers and, people's names are going to be out there. And so I did not want the publicity of picking someone who raped a child because, these things go in that you have to make those considerations. So it took a long time to come up with, if you will, friendly plaintiffs that, would not cause a huge public uproar as to what it is I'm trying to do. So once we settled in on, I think we have maybe 10 or 12 plaintiffs that were courageous folks, let me tell you, because I made it clear up front, your name is going to be in the newspaper. I can't stop that, and they may contact you, but so these were very courageous people that were willing to let me use their names and their backgrounds as to step up and be plaintiffs in the case. And we've sued just about anybody that's connected to the registry in Maryland. The state itself, of course, the Attorney General, Department of Public Safety, every local police department where these folks have to report, the juvenile justice, head of the Juvenile Justice Agency, everybody is a defendant in the case. So we're at the stage right now where I'm waiting for the response from each one of those defendants.
Thank you, Nancy. We got a question back here. We're running short of time, so I'm going to try and move us along. So the question is about the California commitment for civil commitment of detainees, and could that be a test case for a class action? And what would be the best strategy? And if I can just kind of jump in, what I'm kind of gathering from what you're saying is what happened in Maryland is we had a good case, right? We made some good law, and then we've got a statement of law, and then we brought in a class action to say, hey, you got to follow this law for all of these other people as well.
That was my follow-up. I was going to make.
That's a beautiful strategy, right?
You don't do the class action is the initial. Right. Yeah, we didn't file the class action at the beginning. So that's not the way to go. But it's the way to go once you got some great case law.
Right? So the idea maybe in California would be find the perfect litigant, right? The person who will morally just be to the court seen like this shouldn't be civilly committed, this shouldn't happen, and win on that case, get some law in the appellate courts in California, and then pursue a class action on behalf of all the other people who are similarly situated.
Can I just, and you don't necessarily need a class action, and so you talk about civil commitment, there was just this case out of Minnesota where a federal judge just said was unconstitutional the Minnesota civil commitment scheme for a variety of reasons I can explain later. And it wasn't I don't even think it was technically a class action. It was just a couple of lead plaintiffs who represented everybody. They made a facial challenge and an as-applied challenge, and he found facially it was problematic, and that applies to everybody there. So you didn't necessarily need to certify a class to do that. So, it's a complicated litigation, but it can work without necessarily class action to the benefit of many.
Okay, last question, then I'll move on to another slide.
And I think it'll be a quick answer probably, but I've always wondered if there would be a way in through the back door with some of these class action suits, because sex offenders or people convicted of these offenses are not looked at favorably by the public or the court systems a lot of the time, whether families of registrants could come together as a class action suit. Because, those of us that have chosen to stay with spouses or whatever are being affected by these laws too.
Absolutely.
They're innocent.
Absolutely.
So what are your opinions about that?
Didn't that Doe case that we just had on the teleconference talk a little bit about the impact on families?
Yes.
Yeah, so it's starting to get in there in jurisprudence. I think that's a viable attack. Again, you need probably move for declaratory judgment, get your perfect plaintiffs in there, get the family in too.
The problem is the problem is the family member needs to have a right that's being affected. So I hate to go back to the Supreme Court. There was another Supreme Court case this week or last week where a wife sued on behalf of her husband who was trying to get a visa to come into the country, and the court said, you, the wife, don't aren't entitled to anything just because you're married to him. It's his rights, and he can't come into court. So you have to develop a theory where you have a right that's being affected, not your spouse's or
And I
family.
would like to talk more.
So how your due process rights, right, as a citizen, or your right to travel, your right to association, all these constitutional rights. And where do we look again? Do we look to the federal Constitution? No. We look to our state constitutions. Yeah.
Well, as a family member who was affected, I am married to a person who's currently incarcerated. The first thing that he had to do was turn in the last 3 years of our joint income tax return. Where are my rights to privacy?
Yeah,
all of our property is owned jointly. Don't I have any rights?
Well, maybe you do. Maybe, and unfortunately, the answer is maybe and maybe not. And you know, I mean, the legal question, the legal language of the issue is whether you have standing to sue, and you have standing to sue if the courts believe. Forget what you think. Forget what I think. It's all, you know. It's what I talked about before. It's the rule of five. Right? If you can convince 5 people on the U.S. Supreme Court, because they can undo what the lower courts have done, and as they do with some frequency, you know, if you can convince 5 of them that you have an interest that they care about protecting, then you have standing, and then you can sue.
Okay, I want to just ask one, we have about 5 more minutes now. A quick survey of, as far as you know in your local state registry, are there restrictions on access to social media and the internet?
Yes.
Yeah, right? So, you know, my thinking of that is that's like a letter, right? That's writing a letter these days. That's how we communicate. Have you guys had any clients walk in the door or had to address this in any way yet? Go ahead, Nancy.
I did in federal district court in Maryland. A gentleman who was on the registry and had to give over all of his internet identifiers, all of that information, which is a part of Maryland law as well. And we challenged it on First Amendment grounds, the grounds being very specific, that you have a right to, under the First Amendment, to remain anonymous in what you post. You know, in fact, a lot of people post anonymously your political opinions, whatever. And we were successful in the district court level, and the state did not appeal. So, and the judge found it very interesting, he thought. So that's my only interaction with that, though.
There was just a case out of Michigan that had the same thing. They challenged a lot of things, but they were successul on the internet stuff. Yeah.
Great.
Hey, just interject one thing. California, more specifically Ninth Circuit, Doe versus Harris, three-judge panel, got rid of the whole scheme in California for
Doe versus Harris in California. A judge declared the entire, I guess, restrictions on internet access. And
correct. Now, Montana actually came up with a law for emails, which after the fact, I'm not sure how that can happen, but that's a second one.
kind of the new frontier, going to be social media.
And there's also a difference, though, between having a restriction because you are on probation, and those are normally, unfortunately, legitimate. So, like, you know, we can limit you from going online because you're on probation or parole. Those are going to be virtually impossible to challenge, versus you're done with your criminal time and it's just by virtue of registering. Those are much more fruitful, I think, in the way Nancy just
Our last question.
Are we talking specifically about prohibitions against participating in social media, or the release of all of your information and your identifiers and stuff?
Both. Depends.
Yeah, I was talking about use of social media, but certainly.
In South Carolina, there's no prohibition against using it, but you have to turn in all your online IDs and email addresses.
That's the way
That's the part that's problematic. Yeah.
Okay, guys. I'd like to thank everybody on the panel here for their time and expertise. I think we have a lunch break for 30 minutes. I'd like you all to use this information, go out there and get the real monsters, these bad laws.